Hello, everybody. Hello. Good evening. Good evening. Welcome. Welcome in. This is, I had not planned to go live, but if we've got something brand new that's, we gotta talk about, we gotta talk about it, right? Welcome. Yes. Yes. Hello, Menti. Me too. Me too. It was hard to not peek, but I wanted to, go through it the first time with everybody here. Hello. Welcome, welcome. So I am off of my normal schedule of 8 p.m., I guess, Central. So sorry about that, but sometimes things just happen when they happen here. So welcome, welcome, welcome. I think this is pretty exciting, I guess. I don't know. I'm a lawyer, so I guess that's dorky to say, but this is a pretty big deal to have a state sue the federal government for separation of powers issues. That's pretty major. All right, Sin. Woohoo! Hello, Rebecca. Yes, he did. He did. Here. So and it's I think that's great for when you are in a situation like this. You got to know how to use the courts to your advantage. So hello, Lee. So I think that's good for him. I am Bruce Wayne's mother. Hello, Dave the Angry Lawyer. You have a question. Let me see if I can do this. Hold on here. I have a new setup here with my stuff. So hold on. Let me see. Oh, can we do it? All right, here we go. Fingers crossed, all right. Okay, do we make it?
We did. Hello, D.
Yay, we made it. Oh my gosh. Yay, I'm so glad.
Hi.
It's been a
Thank you for bringing
while.
me up. I've been around. I've seen you're joining other people's panels, I've noticed,
Yes, I am.
which is,
I've got a toe in. I'm working on it, so I'm just doing a little bit. But yeah, it's been fun.
yeah, no, I love panels, so yes. But I have a question which I think you can answer. And the reason this question I have is because I have someone who works with a bunch of very interesting people, and we were having a discussion about this exact thing. And I was mentioning the fact that someone is going to be suing, and a state is going to be suing the feds. We were talking about this on Sunday, and I
Mm-hmm.
had a thought. Does the Supreme Court have original jurisdiction? They have original jurisdiction in state versus state. This is state versus federal. So I am wondering if they have original jurisdiction. I see it is going into, I see they're filing in the district court. Could they have filed in the Supremes?
Good question. Good question. Unknown. That's really unknown. I mean, I haven't dug in far enough, but I just wonder when we come here into Article 3 here.
Your little pocket
I
constitution.
can't
I
I
love it.
can't help it. I'm a dork.
You would be both. I mean, and I thought to myself, and I completely forgot looking it up today because I was busy in the office, and then I saw this. I was like, "Oh wait, let me ask D. She'll
Oh
know."
yeah, it's perfect. It's perfect. Judicial power of the United States shall be vested in one Supreme Court. Right, right. So judges, both Supreme and inferior courts, office for life, whatever, receive for their services compensation. Right. So the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority to all cases affecting so on and so forth. So I think because the U.S. is a party, I think you
Hmm.
could argue that, yeah, they do have original jurisdiction.
So why the heck isn't he going there? I think I would want to because this is however this goes, it is going to be going to the Supremes likely in the next few days because I can't see any court not taking more than 24 hours to make a decision on this kind of injunctive relief.
Sure, sure. Well, I don't really know. I'm wondering if this is part of the strategy. Again, I'll have to kind of dig in and take a look at what the laws are here that they're saying were violated. I don't know that it'll go that quick actually up to the U.S. Supreme Court.
You don't
I
think they're gonna rocket docket this?
Oh, I don't think so. No, no. I think as long as that nothing really combusts, I don't think they will be in a big rush. That's my thought. I could be completely wrong.
I'm thinking that this is based on the judges in the Northern District. They're gonna grant the injunctive relief. I'm
Hmm.
thinking that's going to be done, which then takes us to the Ninth Circuit. Ninth Circuit is likely going to uphold, and both of those have to be done quickly. So
Right.
now you have the Supremes. Which judge is who is the assigned judge for California? Because I don't know that off the top of my head. The Supreme Court judge for California.
I don't know either here. This is all I've got.
Right. Well, I'm just thinking about it from a strategic perspective to see how
Hmm.
quickly, and I can't see this. I can't see it not going rocket docket, mostly because this is a very emergent situation.
Hmm, I'm not sure. I'm not sure.
Now, I am just going to add one thing because I'm sure this is going to get into your discussion tonight, and then I'll
Yes.
drop.
Yes,
So a
yeah.
lot of people, so a lot of people are going to be talking about the fact that the Marines have been mobilized.
Hmm.
Yesterday there was a press release from Northern Command,
Hmm.
that stated that there are indeed 500 Marines that have been made ready, but they are only, based upon the communique from Northcom, they are only going to be used to protect federal facilities. So he's
Yes.
not sending Marines into the street, or at least the Marines aren't going into the street.
Right, right.
So
And
just so you know.
yes, thank you. And I'm glad you could confirm that. That was my guess, is that they would be being careful about jurisdiction. Everyone's going to be tiptoeing around. So, like, even if they go across the street and they're into a different jurisdiction, they won't be able to do what they want to do. So,
Well, I truly don't think they want to. I can't see a Marine wanting to take up arms in any way against a citizen. I just don't see that happening.
I don't see that for any of our
Oh
military,
yeah,
honestly.
definitely,
Yep.
definitely.
Yep.
And anyway, and somebody in the chat said 700, and yes, somebody on Twitter said 700, but according to Northcom, it's 500. Just so,
Okay.
yeah,
Well, thanks so much for stopping by. Oh my
no
gosh, it's
problem.
always fun to chit chat with you.
And thank you for answering the question. This is going to be a weird one.
It
Have a good
is.
night.
Bye. All right, everybody. Hello. Hello. And that was Dave, the angry lawyer. Oh my gosh. We have been chatting for, oh my gosh, a couple years now. I always love to get his take on things. He puts together some very interesting posts that are thought provoking and does like to hang out sometimes and join different lives. So if you're not following him, they have, yes, so he's very interesting and lovely. Thank you so much for popping in, Dave. I appreciate that. Can you link the pen somewhere? I can't link it, but I can show you the shop that I got it from. This is the Etsy shop. I bought it online through Etsy, and this is the artist here. And she's actually a really, really sweet, sweet woman. Yes, yes, yes. Thank you so much. Yes, Dave. Of course, of course. Love to hear your perspective. All right, everyone. So, all right, we're screenshotted. So let's dive in. I had not planned to come back on again tonight, but when the governor of California sues the president of the United States, I think we should talk about it. I think that's okay. Yes, yes. I had my rainbows on earlier today. Oh, good. There you go. Yeah. Yeah. So, and again, I've said this before. The fact that they picked California to pick this fight with is like, what are you guys doing? So let's take a look here. I've not read through this yet, so I wanted to have a fresh first impression with everyone here as we get forward, get going. Was that on your bingo card? No, but I don't know. My bingo cards are pretty full right now. I really don't have a lot of room for anything extra. Oh my goodness, thank you so much. Oh, that was so sweet. Let me make sure here that I get a sticky note out so that I don't forget. These posts, yes. Oh, they're doing a great job giving, just the facts. So I think that's really great. Right. Oh, thank you so much. Yes, of course, everyone. So this is the month where we need extra rainbows and extra support for our LGBTQIA plus community. And so I've got several sets of nails that I'll be putting on throughout the month just to celebrate that. All right. So this is Newsome here. Newsome versus, and then I'm not going to put his full name regular because that could be a problem. So there we are. Oh, is she on vacation? Okay. Well, everybody needs to have a little bit of a break. Here's this. And so this was lawsuit filed today here. Filed today. All right, which is the 9th. All right, here we go. Taco. Are we calling him Taco? I don't know. I don't know. It's kind of hard to... I have a hard time calling people food. I know I'm calling him Mr. Orange, but after the color, not the fruit. Oh, I think it'll be okay. Maybe I will try that. Yes, of course. He doesn't like it. Okay, that's a great motivator right there. Taco deserves better. That's kind of what I'm thinking too. All right. Let's we can call him a tostada. I don't like those. I'm not a big fan of the tostada because they're too messy. So we'll call him the tostada. Oh my gosh, everybody, we're all going crazy here. We're going crazy. Oh my gosh, that's so funny. Jurisprudence relates to all law. I'm not sure what you mean by jurisprudence. Like you have a doctor of jurisprudence. I'm not sure exactly. Taco Loco. Post-it no fun. Yes, I have definitely been going through the post-it notes for sure. Let me just check here. I promise I will get into the document here in just a minute. This is just kind of a spur of the moment. Thought I'd turn my camera on and hang out here with everyone for a little bit. Let me just see here. Yeah, I'm not sure exactly what you mean. You'll have to be clearer than the science of law. Black's Law Dictionary Jurisprudence. All right. And anytime I get my Black's Law Dictionary out, I like to make sure and kind of wave to the schmatzy who just hangs out here because we have to remember who we're fighting. And let's look up the J. J-H-I-J. Jurisprudence. Okay, here we go. Sorry, everybody, I get distracted easily. Ooh, oh, that's right. I'm sorry. Distracted. Focus. Oh, there's the singular form of it. That's interesting. Here we go. Okay. Jurisprude. Oh my gosh, we got to read this one, everybody. Off topic, just for a minute. Side quest. Jurisprude is someone who makes a pretentious display of legal knowledge or who's overzealous about the importance of legal doctrine. Oh my gosh, that's so great. All right, so jurisprude. Oh my gosh, that's so funny. I love it. All right. Sorry, distracted. Right, study of law, more modernly study of the general fundamental elements. Yeah, I'm not sure. Can you maybe be a bit more specific? Yeah, I'm not sure. You're saying Are you thinking of, yeah, jurisprudence? I know, right? That's gonna be my new favorite thing ever. Yeah, I'm not really sure what direction we're going in. Yeah. Sorry about that. I'm not sure what you're talking about. Jurisprudence is the study of law. There's different kinds of jurisprudence, and then it all, aka gonna. Oh my gosh, Lexi, yes, yes, that's right, exactly right. Jesus, praise. That's so funny. Some people I think get mixed up with res judicata. So I was like, were they talking about res judicata? That's that's not jurisprudence. Jurisdiction, maybe, right? Juris doctorate could be. There's all different ones. So this is my pocket black dictionary. If you have a big pocket, you can use this. I don't really recommend dictionaries. You can just use your phone, but I'm a visual person. How does a JD apply to all law fields? Well, it's a doctorate, so it's just an advanced degree. And then if you go take the bar and become licensed, then you've got that ability to actually practice law. So it's like a PhD or something like that. Really, I know, right? The cargo pants, they make me so happy. All right, let's dive in here, everybody. So we've got a lawsuit that was filed here, California versus here. Now, California has filed, I don't know, maybe 6 or 7 lawsuits or have been part of maybe even more than that. So California is definitely involved in the litigation against this administration. But this one's specifically saying it's the governor versus the president here. Might fit in the pocket. That's funny. I know, I'm on so late here, everybody. Sorry, I apologize. Oh my gosh, look at that. Oh my goodness gracious, that's adorable. Oh my gosh, that's so cute. It is. It's another language. It truly is. All right, here we go. Introduction. The governor of the state of California and the state of California bring this action to protect the state, that was crooked, against the illegal actions of the president, secretary of defense, department of defense to deploy members of the California National Guard without lawful authority and in violation of the Constitution. All right, so when we talked about this before, the National Guard is a very unique because technically they are protecting the state, but they can be federalized through different pieces of law, which would flip them into federal law jurisdiction. All right, so we've got 2 of those. Excuse me. Here we go. One of the cornerstones of our nation and our democracy is that our people are governed by civil, not military rule. And that's, again, what we've been talking about. When we talk about martial law, that is military rule. And that means, again, that our regular civilian courts are no longer functioning. The founders enshrined these principles in our Constitution that a government should be accountable to its people, guided by the rule of law and one of civil authority, not military rule. Excuse me. Not being able to leave the building. Oh, you have to be a little bit more specific, like the National Guard, the military, the protesters, or people that have been picked up. All right, next. Sorry, I'm not quite sure. Let me get through a little bit more of this here, and then I'll let it simmer here. President Trump has repeatedly invoked emergency powers to exceed the bounds of lawful executive authority. Now, I pause here only to remind everybody, I did a live earlier today where I went through the guide to emergency powers and their use. This is put together by the Brennan Center for Justice out of New York Law School, and they go through and talk about they've just got such great articles in there and talking about what's been declared as an emergency and whether or not different statutes have been unlocked. So highly recommend that if you're interested. Next, here, so keep that in mind. On Saturday, June 7th, he used a protest that local authorities had under control, which we know again is a very important piece of the Insurrection Act. If you're under control, you're good to go. To make another unprecedented power grab, this time at the cost of the sovereignty of the state of California, and in disregard of the authority and role of the governor as commander-in-chief of the state's National Guard. Ouch. That's a burn. That's a pretty big burn. The vehicle the president has sought to invoke for this unprecedented usurpation of state authority and resources is Statute 10 USC 12406. That's been invoked on its own only once before and for highly unusual circumstances not presented here. Invoking this statute, the president issued a memorandum on June 7th, quote, calling into federal service members and units of the National Guard. Secretary of Defense, in turn, issued a memorandum. I don't want to say these letters, and I will kind of keep this word down because I have gotten dinged when I've used these words before. That same day to the adjutant General of California, ordering 2,000 California National Guard members into federal service. And on June 9th, Hegseth issued another memo ordering an additional 2,000 California National Guard members into federal service. So again, this is showing they start off at the state level and are many times can be interchanged with militia when it comes to the Constitution. And then they have moved into federal. All right. These orders were issued despite the text of Section 12406, which, among other things, requires that when a president calls members of the state National Guard into federal service, pursuant to that statute, those orders shall be issued through the governors of the state, right? And that's kind of the key here, is that they aren't doing it properly. I would remind you, though, that they were not allowed to fire certain people without proper cause going through Congress. They did it anyway. So that's, we're kind of in a situation where, no, they shouldn't do it, but they did do it. So now we got to run after them. And we're not very fast runners in the legal system. Instead, Hegseth unlawfully bypassed the governor of California, issuing an order that by statute must go through him. Yeah, of course it was Hegseth. All right, as a result, the National Guard has been deployed to Los Angeles. And now, on top of the National Guard, defendants are reportedly also deploying Marines to the area. The president's federalization and deployment of the National Guard for reasons not authorized by law and without input from or consent of the governor contravenes core statutory and constitutional restrictions. Use of the regular armed forces is similarly unlawful here. All right. So again, and this is where I had started when Dave, the angry lawyer, had come and hung out with us. And he had said this is going to be fast-tracked up through the Supreme Court, and perhaps it will be because of these very issues, but we will see. The Constitution reserves to the states power over their respective state militias, now the National Guard, unless the state requests or consents to federal control. Only under the most exigent of circumstances can the president, over the objection of a state, call the National Guard into federal service. The balance the framers struck between the state's power to control its own militia and the very narrow circumstances in which the federal government may take command and control of the militia serves as a vital check against federal overreach. Section 12406 does not provide the authority defendants have claimed and cannot be the vehicle for their actions. So again, this is just the modus operandi for this administration, everyone. It's repeatedly done over and over and over again, where they will pull a piece of law and they will say, we're going to tell you what it means, as opposed to actually doing what it says and means. So that's that's kind of an issue that goes on here. Hello, hi Micah. But again, that's really something this administration just does. They just pull all kinds of pieces of law, like the birthright citizenship. They're like, man, we'll just change that. All right, the Constitution grants the states, not the federal executive, the authority to conduct ordinary law enforcement activities and to determine how their own state laws should be enforced. Reflecting the founders' distrust of military rule, the U.S. Constitution and the laws of our nation strictly limit the domestic use of the military, including the federalized National Guard. The Posse Comitatus Act codifies these strict rules, prohibiting the military from engaging in civil law enforcement unless explicitly authorized by law. So we'll do a quick side quest here just to let you know when they're talking about Posse Comitatus. This is the section of the U.S. Code here. And then also it goes hand in hand here with a restriction on direct participation by military personnel. And that's 10 U.S. Codes 275. So 1385 here. So if you're looking for where that is in the code, there you have it. The authority to use the military domestically for civil law enforcement is reserved for dire, narrow circumstances, none of which is present here. Again, I mean, I just have to remind everybody that we have a similar situation with the IEPA case. Hold on here, let me grab this abacus. With the IEPA case, right? So Oregon versus Trump, there's a whole bunch of states here, and the judge came in, granted the summary judgment, and said, your emergency situation here, this is, not right. And so you're reading the law incorrectly, not the proper way to read the law. All right, and that was my chair, just clarifying things. All right, everyone. Defendants have overstepped the bounds of law and are intent on going as far as they can to use the military in unprecedented, unlawful ways. Yes, it appears that the Trump administration intends to treat Section 12406 as a mechanism to evade those time-honored constitutional limits. But the statute, like the AEA, right, the Alien Enemies Act, makes it so that they could try to argue that due process wasn't needed. All right, so here again, we're saying, well, they're saying the constitutional limitations aren't in place because of how we read this piece of law. But the statute provides no such authority. This court should reject the unlawful attempt by defendants to wrest away the state's control of its own National Guard for improper and unjustified ends. So this is a problem here, all right? This is kind of a big deal. We're in a groundbreaking moment with Posel, perhaps that could be. Who? Yeah, great question. Well, here we are. I mean, we're in the courts. And I would remind you too that any member of the military, that comes in and attempts to participate and do local law enforcement, you're going to get into trouble. You can get charged with an actual crime. So each individual member of the military needs to know that your following orders is not going to protect you if we're in a posse comitatus situation. All right? So just as a little FYI out there. Whatever. Right. Yes, make sure to use an emoji if you are doing sarcasm. The trolls have been taking a little bit of extra caffeine lately. Right. Well, we got to see what happens before we can pull the posse comitatus out. We have to see how things are unfolding. It's just too soon to be able to pull it up, but that's why they're bringing it up here. So they're saying, hey, under this piece, it's improper and it's unjustified here. All right, next, here we go. Jurisdiction and venue. Up here, the court has jurisdiction. Under here, the venue's proper. Here, I'm skipping through jurisdiction, everyone. That's not, let's just see here. Yeah, I don't have local California rules, so I can't go through. Where's Hawk? Hawk, where are you at? What are your California rules? Are these all right? Well, we'll hope so. And I know that you speak for the entire state of California. All right, parties. Oh my gosh. Plaintiff Gavin Newsom is the governor of the state of California. In his capacity as governor, Governor Newsom is the commander-in-chief of the California National Guard. And then citing the Constitution there, Attorney General Rob Bonta is the chief law enforcer law officer of the state of California and head of the California Department of Justice. He has the authority to file civil actions to protect California's rights and interests and the resources of this state. Citing case law here and quoting case law, we have the Attorney General has the power to file any civil action or proceeding directly involving the rights and interests of the state and the protection of public rights and interests here. Okay, defendant Donald Trump. Boy, they really didn't waste any time putting that defendant in front of his name again. Is the President of the United States. In his official capacity as such, he's issued a memo on June 7th directing the federalization of the National Guard. He is the Commander-in-Chief of the U.S. Armed Forces, including the National Guard, when under federal control. He is sued in his official capacity. All right, Defendant Hegseth is the Secretary of D and head of the Department of D. On June 7th and June Hegseth issued memoranda ordering California National Guard members into federal service. He sued in his official capacity. I love seeing it in the document again. I know, right? Thank you for all you do. Oh, well, thanks so much, Nikki. Yeah, of course. Got to break it down. Defendants, U.S. Department. All right, so I'm not going to say that. So here is a department of the executive branch of the United States government responsible for coordinating the activities of the United States Armed Forces, including National Guard, which when under federal control. So here, the DO of this and Hegseth shall collectively be referred to as the DOD defendants. Maybe we'll call them the DOD defendants. I don't know. Someone's keeping an eye on my how many times I'm mentioning that word. All right, here's the facts, everybody. So this, if nothing else, we'll be able to see California's perspective on what's happened here. Immigration raids give rise to protests. On Friday, June 6th, Immigration and Customs Enforcement, ICE officers carried out enforcement actions at multiple locations within Los Angeles County and the city of Los Angeles. According to news reports that rely on statements from the DHS, ICE officers were executing search warrants at various locations, including outside Ambiance Apparel, a clothing wholesaler. ICE reportedly also carried out enforcement activities that included detentions and arrests at a donut shop in the fashion district of downtown Los Angeles and 2 Home Depot stores in the Westlake district in Los Angeles. Oh, man. Prior to the ICE operations, federal officials did not provide the leadership of the Los Angeles Sheriff's Department or Los Angeles Police Department with any notice as to the planned operations or otherwise attempt to coordinate activities to protect the safety of the public, which you should probably do. You should probably give them a heads up. During the course of these operations, ICE and its agents reportedly took actions that inflamed tensions and provoked protest. On information and belief, agents engaged in military-style operations while conducting these detentions and arrests that sparked panic in the community. That's not de-escalation. For example, in some instances, ICE agents were reportedly observed sealing off entire streets around targeted buildings and using unmarked armored vehicles equipped with paramilitary gear. In all, the Department of DHS reported that its enforcement activities on Friday, June 6th resulted in the arrest of approximately 44 individuals and 70 to 80 people detained in total. That same day, members of the public gathered in protest at the Edward R. Roybal Federal Building and U.S. Courthouse. This building, located here, includes a detention facility known as B-18. On information and belief, protesters gathered at this location based on reports that individuals who were detained during the ICE operations were being held there. Protesters also gathered at other locations where ICE operations were reportedly happening, including the city of Paramount, a city in Los Angeles County. Okay. Oh, while not unified in their views or tactics, most protesters seem to have gathered to express their opposition to the manner in which the Trump administration has executed its immigration agenda and to express solidarity with and concern for the individuals and families most directly impacted by the enforcement actions taking place in their community. During the protests, Service Employees International Union of California leader David Huerta was injured in the midst of interactions with federal agents. He was arrested, treating at a nearby hospital, and then detained. Federal authorities have alleged that Mr. Huerta was obstructing federal agents' access to work sites, where they were executing a warrant, while in contrast, union representatives have reported Mr. Huerta was detained while exercising his First Amendment right to observe and document law enforcement activity. The arrest of Mr. Huerta, who remains detained as of the date of the filing, led to further upset in the community. Hydrate! Thank you. Here we go. I'm not sure if he's out or not. I mean, I'm hoping he's out at this point, but he's been released. Okay, thank you, Linnell. I was wondering. I was like, boy, he better be. My goodness. All right, protests continued on June 7th and June 8th. Most of those involved in protesting have been exercising their rights under the First Amendment in a peaceful, nonviolent, and legally compliant manner. Right. There have no doubt been exceptions. News reports have shown some individuals in the midst of these protests breaking the law and acting violently, for example, by throwing objects at law enforcement officers and damaging property. Don't do that, people. Don't do that, all right? Including by setting fires. Also, don't do that either. That's not good. The arson charge is going to come back to haunt you. State and local law enforcement agencies have responded to such actions, and Governor Newsom and other state and local officials have unequivocally condemned such conduct and called for the prosecution of such law breaking. As it should be, as it absolutely should be here. He's still facing felony charges. Yeah, yeah. We'll see how that goes down. At no point in the past 3 days has there been a rebellion or an insurrection. This is key language for being able to use the Insurrection Act, all right? So they're setting that up for their legal arguments. Nor have these protests risen to a level of protests or riots that Los Angeles and other major cities have seen at points in the past, including in recent years. So they're also saying, hey, we have enough law enforcement and capability here to keep this under control, which is another piece needed in the Insurrection Act. The protests and unrest of the past 3 days pale in comparison to a host of examples, including the time the National Guard was last federalized for riot control in 1992, when then governor's request during the Rodney King riots. That unrest involved thousands of people across Los Angeles County, resulting in multiple shootouts, over 60 unalives, thousands of people injured, and more than 12,000 arrests. Oh my goodness gracious. All right. Oh my gosh. I remember actually, I flew into California. I had a week that I stayed with some friends at that time. And I remember going through the area where the riots had been, and it was just absolute destruction. I mean, what you could see. Most of it you couldn't go into, of course, but that was pretty bad. I'm aging myself here, everyone, but I think that's important. Yeah, the Rodney King situation was really, really awful. B, local authorities quickly respond and are able to control and manage conditions. Again, another thing needed in order for this, in order for the Insurrection Act to come into play, you need, again, to show that the state and local law enforcement are unable to fulfill their duties, right? So again, they're setting this out. Both the Los Angeles Police Department and the Los Angeles Sheriff Department have substantial training and experience responding to protests and large-scale riots. The last instance in which it was determined there was need or want for intervention of federal authorities occurred in 1992, and the above described circumstances that stand in sharp contrast to the events that commenced on June 6th. LAPD, LASD have been responding promptly, professionally, and effectively to the events unfolding in the city and county. Officers from both departments have been on the ground, actively enforcing the law, issuing and enforcing orders to disperse and protecting public safety and property, as well as federal personnel. So, right, and as we went through the Insurrection Act earlier today, again, we kind of went through these multiple elements needed in the Insurrection Act. And so that's another piece. If their own federal people are not safe, then that would be another reason that would allow for the usage of that. Oh, okay. Yo, you're so young. So young. Here we go. Back in it, federal personnel. In the afternoon of June 6th of 2025, sometime after protesters had gathered near the federal building and its B-18 detention facility, federal agents sent a request to LAPD for assistance. Within an hour, assistance from LAPD arrived on the scene and began coordinating their officers to address the situation with the protesters. LAPD would have responded sooner had federal officers coordinated with LAPD prior to engaging in the enforcement actions. This is really huge here. This is definitely a state sovereignty issue. If you're coming into somebody else's jurisdiction, it's just like basic manners to give them a call and be like, hey, we're going to be in the neighborhood. That's just basic manners for anyone. Federal officials did not, and as a result, LAPD was unable to proactively plan for the potential incidents, for example, by pre-positioning resources, and it was not positioned to immediately deploy appropriate staffing and equipment. You're for? Oh, right. It was, for me, it was my past life is when I was there. Around 7:50 p.m., LAPD declared an unlawful assembly in the area of the protest site at the intersection of Alameda and Temple Streets, and it issued an order for the protesters to disperse or to be arrested. By approximately 8 p.m., the crowd started to disperse, with LAPD officers blocking their path back to the B-18 detention center. Next, a few hours later, LAPD received a report that another crowd had gathered outside a parking lot in Chinatown. The group dispersed as federal agents established a perimeter. ICE immigration enforcement activity continued the next day, Saturday, June 7th. Protests continued in the city of Los Angeles that were, by all accounts, peaceful. The LAPD issued a statement that night that demonstrations across the city of Los Angeles remained peaceful and commended those who exercised their First Amendment rights responsibly. So that's really good. Oh, was that? Oh, thanks so much, Lucky Fox. Oh, yay, win for me. Earlier in the day, outside the city, but within the county of Los Angeles, there were other protests. At approximately 10:15 a.m., personnel from LASD responded to the 6400 block of Paramount Boulevard in Paramount, California, following reports of a large crowd gathering in the area and obstructing traffic. Upon arrival, LASD deputies observed the presence of federal law enforcement officers and a significant number of individuals gathering to protest. Federal officials did not give LASD any forewarning of any of the planned operations in that area or otherwise attempt to coordinate activities. This is definitely a ding against them. I know I keep talking about it, but if you've ever worked in any kind of situation where you're working with multiple different kinds of law enforcement agencies, if they don't talk to each other, that's like a huge disrespect moment there. So LASD positioned its officers around the intersection of Alondra Boulevard and Atlantic Avenue and deployed less lethal weapons. At approximately 4 p.m., LASD declared an unlawful assembly and instructed individuals to leave the area or be arrested. So this, again, you might say, well, First Amendment right to assemble, true. But it is okay under the U.S. Supreme Court for there to be some regulations on time, manner, and location. And that's just for basic safety reasons. So they can put some of these, checks into place just to make sure everybody's safe. That's a good question. Does sanctuary state declaration affect this? I'm not sure. That's a great question. And instructed individuals to leave or be arrested. Officers shot tear gas canisters into the crowd and protesters retreated. By 7 p.m., approximately 100 protesters had gathered on the other side of the 710 freeway near Atlantic Avenue and Alondra Boulevard. At about 9:30, a line of LASD deputies and vehicles began moving towards the crowd, forcing them back, and by midnight, most demonstrators began to leave. That's a good call. LASD's standard practice is to call in assistance from other local agencies, such as the Sheriff's Department, from neighboring counties, and then for direct aid from state agencies when LASD determines that it cannot handle a situation. Again, setting this case up, stating, we have a multi-step plan here if things go a little bit bonkers. We don't just, call in and say, hey, give us the National Guard federalized. So they're saying we have multiple pieces here. These two steps would be done before a request for federal assistance would be made. But LASD did not need and did not request the assistance of other agencies to gain control of the protests. Governor Newsom has also taken steps to ensure that the state itself is actively providing support in close coordination with the city and county, and there are no unmet needs from local law enforcement. Local law enforcement agencies have not requested any assistance, but if they were to do so, the state is more than prepared to meet any needs that may arise. As an example, June 6th and 7th, the state deployed additional California Highway Patrol personnel to maintain safety and order on Los Angeles highways. And again, showing that's what we're... Oh, Ethan people, hello, welcome in. That again is building this case. Like, we've got control of it, and if we have control of it, then your Insurrection Act is not going to be usable, right? You can't use that check. Okay. I promise I have enough vocal cords to get through this. I'm just a little bit rough. I had a vocal injury when I was in college, and so sometimes my voice gets a little bit rumbly, but I apologize ahead of time. All right, so ICE continues to carry out immigration enforcement, including in Los Angeles County. Okay, C, without consent or even official notice to the governor, the president federalizes the National Guard. I mean, this is really precedent setting, and a lot of things are, and I know people are like, oh, we've had enough of it. I agree, but from a legal point of view, it's like, ooh, all right, what's going to happen here? Early on Saturday, June 7th, border czar Tom Homan stated Mayor Karen Bass should be thanking us. Gosh, this guy's different, isn't he? She says they are going to mobilize. Guess what? We are already mobilizing. It sounds like he's got a premature mobilization problem here. We are going to bring the National Guard in tonight. It's too soon. I'm not surprised, but it's too soon, buddy. Over the course of the day, the department did not communicate directly with the governor's office regarding any planned activation and deployment of California National Guard members. That's totally inappropriate. At no time prior to issuing the memorandum to federalize the California National Guard troops did the DOD seek approval from Governor Newsom to utilize California's National Guard to protect federal agents and federal property, or otherwise notify or seek concurrence from the governor or his office regarding the planned mobilization of the National Guard. Right. Did he? We'll never know. We'll just never. It happens when you're nervous. Oh my gosh, that's funny. Hold on, everybody. Don't be afraid. Just a second here. It's just I've just got my light went out. You'll be don't be scared, everyone. My battery pack just blew. Hold on. Here we go. Let's see. Here we go. This is my second battery pack that's blown in the last week, everybody. I think everybody needs to calm down in the legal world because my battery packs can't take it. All right, I've only got 3 more. Oh my gosh, Teddy. Oh my gosh, sorry everybody. All right, here we go, back in it. At 5:13 p.m. on June 7th, the governor communicated unequivocally and publicly on social media that he disapproved of the federal government's plans, which were unnecessary because there is currently no unmet need, and which would be counterproductive because it would only escalate tensions and erode public trust. And here's, where's this? Is this, I don't know what social media this is here. Is this the Twitters? Is this the Tweeterers? I'm not sure. This looks like the Tweeterers, but I'm not on that, so I apologize. The federal government's moving to take over the California National Guard and deploy 2,000 soldiers. That move is purposefully inflammatory, will only escalate tensions. It's Threads. Okay, is it Threads? Oh, it's Twitter. All right, thanks, Willie B. Oh my gosh, oh, should add a battery pack. I know. LA authorities are able to access law enforcement assistance at moment's notice. We are in close coordination with the city and county, and there's currently no unmet need. The Guard has been admirably serving LA throughout recovery. This is the wrong mission and will erode public trust. Yikes. Okay, 5:13 p.m. here. On the evening of June 7th, Mr. Orange issued a memorandum entitled DoD Security for the Protection of DHS Functions. The memo does not identify the Los Angeles protests, the state, or any specific geographic region by name, but instead refers to numerous incidents of violence and disorder that have recently occurred and threatened to continue in response to ICE enforcement of federal immigration laws and to threats to the security of federal immigration detention facilities and other federal property. So, and I think that's one thing too that they're saying, that they're trying to get an angle on here that I think, I'm sorry, I'm grabbing the highlighter, that I think is important to note is that with the detention facilities, depending on how the protesters are acting around these facilities, you got to be careful because they could see that as some kind of threatening behavior. If you're just standing there and listening, that's different than if you're like, within the parameters. So make sure that all behavior around those facilities is appropriate and proper, which I believe it has been here. The memo also states that to the extent the protest or acts of violence directly inhibit the execution of the laws, they constitute a form of rebellion against the authority of the government of the United States. Now that's BS. All right. That's BS right there. To the extent the protests or acts of violence directly inhibit the execution of the laws, they constitute a form of rebellion against the authority of the government of the United States. That is absolute rubbish. Now, I don't usually go into that when I'm reading a document, but if I read something that's so blatantly incorrect, I can't stop myself. All right, where's my red pen? Here it is. This is basically saying, like, if you don't respond within 24 hours, I'm going to assume that you're okay going to jail. That's basically what this is. So if you are protesting, to the extent that protests or acts of violence directly inhibit the execution of laws, what law, inhibit how, and do you mean, criminal actions? Then it's considered rebellion, because once you trigger the rebellion word, now we're back into the Insurrection Act world. All right, so this is where our justification comes into play. I think we worked on this earlier today, because suppressing the rebellion is one of the pieces that allows for the Insurrection Act. And one of the easiest ways to suppress a rebellion is to define it first yourself without actually using the law to define it. So that's not great. That's not great. This is a red flag here. Red flag. The memo states, quote, in light of these incidents and credible threats of continued violence by the authority vested in me as president by the Constitution and the laws of the United States of America, I hereby call into federal service members and units of National Guard under 10 U.S. Code Section 12406 to temporarily protect ICE and other U.S. government personnel who are performing federal functions, including the enforcement of federal law, and to protect federal property at locations where protests against these functions are occurring or are likely to occur based on the current threat assessment and planned operations. So this is a mixed bag because, of course, the federal law enforcement is a piece of, of course, they should be protected along with the properties, but that's it. I mean, again, they're in California, and California does have sovereignty. So their little buildings and people are going to be able to be protected, but you can't take the whole city. Like that's way outside of your jurisdiction. Really? All right. Here we go. The memo further directs the secretary here to coordinate with the governors of the States and National Guard Bureau in identifying and ordering into federal service the appropriate members and units of the National Guard under this authority. The memo specifies that the members and units called into federal services shall be at least 2,000 National Guard personnel. So let's get our numbers sorted here. And the duration of duty shall be for 60 days. So for 2 months, they've got 2,000 National Guard there. I mean, for starters, they've got 2,000 National Guard there. I mean, for starters. Oh, yes. Welcome, everybody. Welcome. Or at the discretion of the Secretary of Defense. Finally, the memo authorizes personnel to perform those military protective activities that the Secretary of Defense determines are reasonably necessary to ensure the protection and safety of federal personnel and property. So this part here, you have to be really careful with this, right? So they're really, really walking the line, because when we go back into that comitatus statute, hold on, let me grab it here, right? And we take a look here at the other piece of it. It says here, no member of the Army, Navy, Air Force, or Marine Corps, or military personnel, which again, we're flipping with the National Guard, can do a search, a seizure, arrest, or other similar activity unless that's been set out by law or authorized by law. So they're trying to basically cast aside this issue of local law enforcement being the one that's supposed to be enforcing the laws here. Hasn't violated the Third Amendment. I think it's coming. We'll see. The provision cited by President Trump for his authority to take this step, Section 12406, states that whenever, one, the United States or any of the Commonwealths or possessions is invaded or is in danger of invasion by a foreign nation. Two, there is a rebellion or a danger of rebellion against the authority of the government of the United States. So here we go. The president's unable with regular forces to execute the laws of the United States. Again, with regular forces, somehow the laws are not being enforced, all right? The president may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. Orders for these purposes shall be issued through the governors of the states, or in the case of the District of Columbia, through the commanding general of the National Guard of the District of Columbia. So in DC is unique with the National Guard because basically the president has control over that jurisdiction. The president's basically like the governor of DC when it comes to National Guard choices. All right, so it's a mixed federal state bag situation. All right, National Guard here. And then number 12, this is only the second time in our nation's history that a president has relied on the exclusive authority of this provision to federalize National Guard. The first was President Richard Nixon when he called upon the National Guard to deliver the mail during the 1970 Postal Service strike. Oh man, that would suck for the National Guard. This is also the first time since 1965 when President Johnson sent troops to Alabama to protect civil rights demonstrators under different federal authority that a president has activated a state's National Guard without a request from the state's governor. Wow. Later in the evening of June 7th, Hegseth sent a memo to the Adjutant General of California, who leads the California National Guard, but also holds a federal commission as a reserve of the United States Army. Hegseth attached the memo, called into federal service 2,000 members of the California National Guard for a period up to 60 days. Yes, thank you so much. Tea break here. The adjutant, right? I just have to spit it out. The adjutant general subsequently shared the Dodd order with the governor's office. However, at no time did the governor or his office provide consent to the mobilization or issue orders through the governor mobilizing the Guard members. So we do not have consent, and that's again important if you're using certain statutes to justify your behavior. Shortly thereafter, on the same evening, the adjutant general relinquished command of the 79th Infantry Brigade combat team to General Gregory. We'll just use first names. I'm worried about the algorithm here. So, commander of the U.S. Northern Command. Since that time, all orders issued to this unit have come from the U.S. Northcom here. Yeah. The service members of the 79th Infantry come from across California. Many members are based in San Diego, but other members have individual residences throughout the state, and the 79th has subordinate units based in various parts of the state, including Richmond, California. When the 300 deployed California National Guard troops and armored vehicles began arriving in Los Angeles on Sunday morning, the city was quiet. The local police and sheriff's department had addressed any disturbances up to that point. On June 8th, the governor's office sent a letter to Hegseth objecting to the federalization and deployment of California National Guard troops to Los Angeles and requesting that Dodd rescind its order. The letter also reiterated that the local law enforcement is more than capable of responding to the situation in Los Angeles. Didn't they fire the JAGs as possible? Are there any thresholds to meet to use the Insurrection Act? Yes, multiple thresholds in order to pull it out and use it. There's two particular pieces, just again as a quick side quest, everyone, in the Insurrection Act here. This piece, section 251, is only if there's an insurrection, all right? This one, 252, can be pulled in if they feel certain laws are being not followed, and only if the state, by ordinary course of judicial proceedings, can't get it under control. So the state has to be out of control in order for any of this to attach here. We don't have to have an insurrection for this section. Could be other things going on, but you do have to say the state did not keep it in control, and so we had to step in. I mean, that's the fatal flaw in this whole situation, is the fact that the state did have control, so that they don't have that as a piece of justification. All right, a letter also reiterated that local law enforcement is more than capable of responding. Right, so on June 9th, Secretary Hegseth issued a second memorandum. Sorry, everybody. I don't know if it's the weather or what. Here we go. Second memorandum ordering the federalization of 2,000 additional California National Guard members. Once again, this order was not issued through the governor and did not provide any opportunity for the governor to review or consent. Again, that's very important. Yeah, I think it's the pollen. While the face of the defendant's orders purport to direct the deployment of federalized National Guard members to protect federal property and federal personnel carrying out their functions, which is allowable, these directives are phrased in an ambiguous manner and suggest potential misuse of the federalized National Guard. So again, another example of how the language can be kind of tangled up here. It is unclear what sections Hegseth will deem as reasonably necessary to ensure the protection and safety of federal personnel and property. Among other concerns, the lengthy duration of the employment, 60 days. Yeah, that's a lot for a protest situation. And location, not just where protests are occurring, but where they're likely to occur. So this is like, we're going to just guess in the future where we think it's going to be, and then we'll go stand there. Indicate that the National Guard may be compelled to accompany immigration enforcement on its missions in any location with potentially dissenting residents. Oh my gosh, that would be awful, wouldn't it? Maybe that's part of the plan, is to be able to have some National Guard in there backing up ICE. So they've got an extra, oh my gosh, I was just thinking that, BW, I was just thinking that. Sleeping on the floor of a federal. Oh my gosh, I know. Oh, it's so terrible. All right. Again, this might be the situation there. That's exactly what they want. Well, right. Yep. But again, and we have to keep this in mind too, everyone. You might say, well, who's gonna make them do anything? They break the law all the time. When you're in front of a court, right? This court that they're in here, where's the Northern District of California, if they're to issue an injunction or if they're to somehow put something into place to make it so that the utilization is not there, that order from the court is more powerful than anything else because that order is basically, the Constitution, and that's whom they've sworn an oath to. Right. So that's important. Here we go. Immigration location. Right. Defendants have already made clear their intention to expand the use of these National Guard members to effectuate interior civil immigration enforcement activities normally conducted by civil immigration law enforcement officers. So they must not have enough officers. Oh my gosh. For example, on the evening of June 8th, Mr. Orange issued a statement on social media purporting to direct DOD and other federal agencies to take all action necessary to liberate Los Angeles from the migrant invasion. It's inflammatory. And he informed the media we're going to have troops everywhere. Already, fear and terror are spreading in communities across California as a result of defendants' actions, and as predicted by Governor Newsom and other state and local leaders, the deployment of the National Guard seems to have only heightened tensions with protesters and residents in Los Angeles. All right, D. He broke up with his boyfriend. He's taking it out in California. Well, and he doesn't want to pay anybody. I think that's really what all of this comes down to, right? Like, I think the Department of Justice has so many interns, unpaid interns doing all of the work now that the work's not, top tier. And I think this is true too. Like, he's like, man, we're not going to pay for the National Guard. They're probably going to make California pay for its own National Guard that's been federalized. Oh my gosh. I wouldn't be surprised. It's all about money at the end of the day, right? Right. And there's not much left in the JAG Corps at this point, is my understanding. They've really kind of thinned out the ranks here. I don't think anyone's winning. This is a no-win situation all the way around. There's no winning. The only thing that can be done is to try to triage it, right? And then clean it up later. Defendants' mobilization of California's National Guard members usurps the authority of the governor and harms the state of California. Defendants' actions unlawfully activating 4,000 California National Guard members into federal service directly infringes on Newsom's proper role of Commander-in-Chief of the California National Guard. Except when the state's militia has been lawfully called into federal service, the governor maintains command and control of the militia. And that's key here, right? The other thing too, when we're talking about our militia, that I really want people to remember, right? You're like, oh, well, the militia, that's basically our National Guard. Guess what? The president's infringing on California's Second Amendment right. I said it. Look at that. As Commander-in-Chief, the Governor of California calls members of the California National Guard to active duty to serve the needs of California. The California National Guard is vital for various state functions, including emergency and natural disaster response and DRUG interdiction. The California National Guard acts to protect people and property in many ways, and the state relies on the National Guard to be ready to intervene in emergent situations to help protect Californians. As a general matter, it is the governor, in conjunction with local law enforcement, who's best situated to determine the resources needed in times of emergency. Oh my gosh, her divine alchemy. Yes, exactly right. By unlawfully diverting 4,000 service members from their state responsibilities for at least 60 days, defendant's action impairs the government's ability as Commander-in-Chief of the California National Guard to call upon the state's National Guard for emergencies and carry out other critical functions. Him not going through Newsom, this could be an impeachable offense. Absolutely. I mean, add it to the list, right? It certainly could be a high crime and misdemeanor by usurping or coming in and clearly disregarding the authority of a governor. Yeah, I mean, that's a pretty big deal. Right. GOP has to agree. Yeah, exactly. There's a lot to choose from. You can really get a wheel and spin it. Maybe we'll do that one night. I'll get a wheel and we'll just put all of the impeachable offenses and just spin it and see what happens. Oh, all right, here we go. The California National Guard, composed of the California Army National Guard and California Air National Guard, has approximately 18,733 service members, with 12,212 available for deployment. Most of the California National Guard members serve as reserve forces, meaning that their role in California National Guard is part-time, and they are generally employed in civilian roles separate from their work as service members. Many of these service members receive specialized training to perform specific duties, and all play a critical role in protecting the state. I think that's really important to note too, of course. Our National Guard, when they come in to help, a lot of them are reservists, of course. As a recent example of the National Guard's important work, in January of 2025, the Guard was called upon to assist in fighting one of the most destructive fires in the state's history in Los Angeles County. Between January 7th, when the fire started, and January 11th, Governor Newsom activated 2,500 service members to support firefighting efforts. Many of the National Guard members were dispatched the same day as the fire began. In addition to firefighting support, the National Guard's provision of resources was critical to assisting local authorities and ensuring the safety of surrounding communities, firefighting brigades, and pilots. This deployment comes when California is in the midst of peak wildfire season for both Northern and Southern California, and may need to rely on their crucial support, as the state did during the Los Angeles fires earlier this year. When the state faces simultaneous emergencies, the National Guard's resources can be stretched thin. For example, in 2020, the California National Guard was required to respond to COVID-19, multiple wildfires at once, and civil unrest, significantly burdening the National Guard's military policing resources, making it difficult to fulfill emergent needs across the state. Such overlapping emergencies cannot be predicted. You're so kind. You're so kind to say that. All 4,000 of the federally deployed National Guard members are now unavailable if natural disaster or other state emergency erupts. These National Guard members, coming from the 79th Infantry Brigade Combat Team, include a large number of Guard members who serve in Task Force Rattlesnake. What? Task Force Rattlesnake? I'm worried. Should I not have said that? The State Specialized Fire Combat Unit. All right, there we go. Fire Combat Unit. These service members have specialized training in wildfire or wildland fire mitigation and prevention and direct fire suppression, and would be highly difficult for the state to replace. The 79th Infantry Brigade also contains counter-DRUG task force members that specialize in providing support to stop the trafficking of the F word at the U.S.-Mexico border. Because of these National Guard members have been federalized for 60 days unlawfully as detailed below, the state of California is deprived of resources to protect itself and its citizens, and of critical responders in the event of a state emergency. Well, I think that's a really good argument here. That's a pretty solid argument. All right. Next, here's our claims then. All right. So again, this is a lawsuit. So we've got to have our causes of action set out, and then also what they're looking for. Yeah, I think it's a good argument. Now, the counter argument to that, the other side of that. So they're saying, hey, you're taking our people, and this is not necessary because we're enforcing what we need to enforce, but you're taking our people and we need those resources. And then the other side will come in and say, well, the president's made a determination that they're needed, and that's within his Article 2 powers. That's going to be the big push, right? Well, he can just do whatever he wants, right? Under Article 2 if he needs to when it comes to the military. That's going to be where the problems lie here. All right, first cause of action, ultravirus. All defendants. So ultra virus, we're hearing a lot about. I'm sure I'm saying it wrong. It's Latin, and it just means that you are exceeding the power that you've been given. So exceeding power. All right. So they're saying he has gone well beyond what he is allowed to do under the Constitution. All right. Plaintiffs reallege and incorporate by referencing the foregoing allegations as fully set forth herein. Neither the president nor an agency can take any action that exceeds the scope of their constitutional or statutory authority. Federal courts possess the power and equity to grant injunctive relief with respect to violations of federal law by federal officials. That's what they're looking for here, is injunctive relief. Right? Indeed, the Supreme Court's repeatedly allowed equitable relief against federal officials who act beyond the limitations imposed by federal statute. Section 12406 requires that orders pursuant to that section be issued through the governors of the state, or in the case of the District of Columbia, through the commanding general of the National Guard of the District of Columbia. Section 12406 originated as part of the Militia Act of 1903. The original section did not include this provision, but the statute was subsequently amended to include the requirement that orders be issued through the government, through the governor. Militia Act of 1908. Boy, we really do like our historical pieces here. I think that's very interesting. Right. Yes, yes. All right. So, quote, a statute should be construed so that the effect is given to all its provisions, so that no part will be inoperative or superfluous, void, or insignificant. Case law here. Further on, a significant change in language is presumed to entail a change in meaning, even when legislative history is silent as to Congress's intent. And further citations there. Really? In 08? Oh, okay. Yeah, I mean, we still had like 10 states that weren't part of the U.S. then, or, I mean, that was a long time ago. As discussed, defendants did not notify Governor Newsom of the orders or attempt to obtain his consent, nor did they issue their orders through the governor as the statute directs. This circumvention deprived the governor of the opportunity that compliance with the terms of the statute would have afforded him at minimum consultation with the president and or other federal officials, not only as to whether the California National Guard should be called into federal service at all, but if so, which service members and in what number should be called and for what purposes and what period of time. So this is so, oh my gosh, everybody, I cannot emphasize how important this is, right? They just went in, they didn't talk to the governor. So technically, the state troopers, let's just use that as an example. The state troopers have to follow the governor, right? The state troopers, local police, county police, all of that. They all are at the command of the commander-in-chief of the state. So technically, it would be possible if you've got National Guard, it's been federalized, so now it's been sent in by the president, and they're standing and doing things that are illegal, right? Because they're saying, hey, this was unconstitutional. And they keep doing it, and the Newsom can come in and has his own law enforcement. So we could see this, not literally a battle, but there's this fight then between the National Guard that's been pulled in, or federal, whatever, and then the state law enforcement. I mean, that's pretty big. I mean, the amount of authority that a governor has over actually enforcing law is enormous, especially in California. Thank you, Brandy. Yeah, I mean, that's a lot. That's a lot. I'm not going to say that that's happening. I'm just saying you have those two jurisdictions colliding then. And it's hard enough for two law enforcement entities to work together, much less the state and the feds, right? No one in the state likes the feds. I'll just put it to you that way. All right, President Trump's memo purporting to call into federal service members of the California National Guard, 12406, without issuing this order through Governor Newsom, is contrary to law and outside the authority granted to the president under that statute. So that's the ultra virus right there. Hegseth's orders purporting to federalize 4,000 members of the California National Guard without issuing these orders through Newsom are contrary to law and outside the secretary's authority. Also true. Defendants' actions are ultra virus for reasons beyond their failure to follow procedural requirements of Section 12406. Conditions in California did not fall under any of the situations set forth in Section 12406 that would allow its invocation at the time it was invoked, nor do they now, nor is it reasonable to expect them for the next 60 days. The statute authorizes the federalization of the National Guard to 1. Repel invasion of the United States by foreign nation, 2. Suppress a rebellion or danger of rebellion against the authority of the government of the United States, or 3. Execute federal laws when the president is unable to do so with regular forces. Again, none of these have been triggered, and if these have not been triggered, then you're not allowed to use it then, right? Is how it's supposed to be. That's how it's supposed to be, right? And then what's so interesting too, though, is because we're in a state situation, we do have that added element of who's going to enforce it being state law enforcement. So there is another side. It's not just federal law enforcement there or the courts alone. The Trump memo does not and cannot assert that California is being invaded or is in danger of invasion by a foreign power, nor has the administration identified a rebellion, which is generally understood to connote an organized attempt to change the government or leader of a country, usually through violence. Something much beyond mere protest or sporadic acts of disobedience and violence, according to Black's law. The memo asserts that to the extent that protests or acts of violence directly inhibit the execution of the laws, they continue a form of rebellion against the authority. This is the red flag phrase, everyone, here. They're quoting the red flag here. To the extent that the protests or acts of violence directly inhibit the execution of the laws, they constitute a form of rebellion against the authority of the government of the United States, but primarily peaceful protesters with some acts of violence or civil disobedience do not rise to the level of rebellion. So they're saying that phrasing is not appropriate. Indeed, nothing about the scale of the protests or acts of violence set these events apart from other recent periods of significant social unrest here. Defendants also have also not shown that any of the protests have rendered the president unable with the regular forces to execute the laws of the United States. Indeed, Newsom and Mayor Karen Bass both reported on June 7th that they had sufficient resources to respond to any potential unrest or threats to safety or property. June 8th letter from the Office of the Governor to the Secretary notes that as demonstrated by the robust law enforcement response yesterday evening to protect federal facilities, local law enforcement resources are sufficient to maintain order. And on both June 6th and 7th, ICE officials were able to act on warrants and make arrests. Right, tea time. Thank you, everybody. I appreciate it. All right, number 91, a violation of the Posse Comitatus Act is imminent, if not already underway. Accordingly, plaintiffs are entitled to a declaration that any action taken pursuant to the June 7th presidential memorandum is invalid and an injunction prohibiting defendants from implementing the memorandum. Right. So, I mean, that's pretty well put, and I think that's very well organized. Here's our second cause of action. So the first one was the ultra-virus piece. The next one is the 10th Amendment of the United States Constitution. So Article 1, Section 8, Clauses 15 through 16, Title 32. So hold up for a second. Oh, where did I put my Constitution? Just a minute. Did it go? Might be in my paperwork here. Oh, here it was. It was under Black's Law Dictionary. It's getting smushed. Here we go. Let's just take a peek here. Article 1, Section 8, Clause 15 through 16. So here we go. Article 1 is Congress. Here, so let's just take a peek and see what they're talking about. Oh, that's the Declaration of Independence. Don't want that. Okay, Article 1, Section 8. This is where they list out all of the things that Congress is supposed to do here. So we're going to go to Clause 15. So 1, 2, 3, 4, 5, 6, 7, 8. 9, 10, 11, 12, 13, 14, 15. All right, 15 through 16. To provide for calling forth a militia to execute the laws of the Union, suppress insurrections, and repel invasions. So this is what Congress is given the power to do. So this is the express power set out for Congress to provide for calling forth a militia to execute the laws of the Union, suppress insurrections, and repel invasions. All right, so we've got another issue here between the executive branch and congressional power. Plaintiffs reallege and incorporate by reference the foregoing allegations as fully set forth herein. The 10th Amendment provides that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. So the 10th Amendment here, a lot of times people will get this mixed up with the 9th Amendment because the language is very similar. But I'll show you just real quick here. Okay, 13, 14, 15, going the wrong direction. Here we go. The 9th Amendment, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So they're saying if we didn't include it in here, if this right is not actually written specifically into the Constitution, that doesn't mean you don't have it. It just means that we've not written it into the Constitution. It's retained by the people, so the people can have it. That's number 9. This is also where the Dobbs case came into play here. The 10th Amendment says the power is not delegated to the United States by the Constitution nor prohibited by it to the states, reserved to the states. So this is state power here. So this is saying we're not going to deprive anybody of any rights that you should have just because it's not written in here. This one is saying anything that isn't prohibited to the states have if the federal government doesn't have it already. All right. So just as a clarification for the 9th and 10th Amendments here. The president's unlawful order calling up at least 2,000 National Guard personnel infringes on Governor Newsom's role as commander-in-chief of the California National Guard and violates the state's sovereign right to control and have available its National Guard in the absence of a lawful invocation of federal power. I think that's a really strong argument here that they're setting out. Under our system of federalism, policing and crime control remain one of the most basic rights reserved to the states. Quote, indeed, we can think of no better example of the police power which the founders denied the national government and reposed in the states than the suppression of violent crime and vindication of its victims. We're citing the Morrison case here. The power to establish the ordinary regulations of police has been left with the individual states, cannot be assumed by the national government. So again, that emphasis on local law enforcement, this posse comitatus situation. All right, so I'm just going to abbreviate that. This is so incredibly important with the local law enforcement and a huge tradition of it. Local control of law enforcement is also essential to the protection of liberty and government accountability. Quote, because the police power is controlled by 50 different states instead of one national sovereign, the facets of governing that touch on citizens' daily lives are normally administered by smaller governments closer to the governed. The framers thus ensured the powers which in the ordinary course of affairs concern the lives, liberties, and properties of the people were held by governments more local and more accountable than a distant federal bureaucracy here. All right, and so we've got the Federalist 45 being cited. So here's our visual for that. Federalist Papers, Hamilton and Madison, and a little bit of John Jay. Poor John Jay, he was sick a lot. Put together a rationale for why we have a central government, why we needed to have a central government. So that's quoting the Federalist Papers. And then we always say hello to Madison. Hey, Madison, what's up? Okay, bye. Deploying over 4,000 federalized military forces to quell a protest or prevent future protests, despite the lack of evidence that local law enforcement was incapable of asserting control and ensuring public safety during such protests, represents the exact type of intrusion on state power that's at the heart of the 10th Amendment. State officials with local officials such as Los Angeles Police Department, Los Angeles Sheriff's Department are in the best position to determine what resources are necessary to preserve public safety amid protest activity and to intervene to enforce public safety and criminal laws when warranted. Further here, the federal government is not merely intruding on the province of the state, but doing so by taking command of the state's own resources, the California National Guard, which remains under state control unless properly federalized. Proper federalization has not happened here. Because of the January 7th presidential memorandum and resulting Dodd order and June 9th Dodd order purport to federalize the National Guard for an unconstitutional and illegal, here we go, last page everybody, purpose, plaintiffs respectfully ask the court to find that the orders are void and that the National Guard should be transferred back to the rightful command and control of the state of California through Governor Newsom. And honestly, I can't think of a single case that has been like this before. I'm trying to go back and think of the cases that have involved militias or state power versus federal power. And I just can't recall any time where we have had a state come in and say to the federal government, give us back our military, or our law enforcement. It's very interesting. I mean, of course, there was the Civil War situation, but that was different. It was a different animal. Plaintiffs are also entitled to a declaration that any action taken pursuant to the June 7th memo is invalid and an injunction prohibiting Dodd defendants from implementing the memorandum. Kent State, I'm just not sure. I really don't know that much about the details behind Kent State. That's going to be on my list of kind of taking a look at. Third cause of action, violation of the Administrative Procedure Act. So this is the APA here. Plaintiffs reallege and incorporate by reference the foregoing allegations as fully set forth herein. Under the Administrative Procedure Act, a court must hold unlawful and set aside agency action that is arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with the law, that is contrary to constitutional right or power, or that is in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. And this again set out in code here. Yeah, I was wondering about that upgrade. I wasn't sure. Again, I've spent a lot of time going through a lot of the what the shenanigans going on in Arkansas in the civil rights movements. So there's a lot of interesting cases out there about that, but I just don't have the knowledge on the Kent State situation. All right, here we go. An agency may not take any action that exceeds the scope of its constitutional or statutory authority. The Dodd defendants lack authority to federalize members of the California National Guard. Tea break, everybody. Sorry about that. Without issuing such orders through Governor Newsom, who has not consented to their actions or been afforded the opportunity to consult on any deployment. Such agency actions are unauthorized, unprecedented, and not entitled to deference by this court. Accordingly, plaintiffs are entitled to a declaration that Secretary Hegseth's June 9th and June 7th orders are invalid and an injunction prohibiting Dodd defendants from implementing the June 7th presidential memorandum. Yes, I will post this up on my Tube of You channel here within the next 24 hours. I've done a lot of lives, everyone, in the last few days, so I'm a little bit behind. YouTube doesn't like it when you just kind of put a whole bunch of them together at the same time. All right, here's our prayer for relief. Last page here, everyone. Wherefore, plaintiffs request that the court enters a judgment against defendants and award the following relief. So this is what they're asking for here. A declaration, the June 7th memo calling into federal service members and units of the National Guard under Section 12406 and Hegseth's June 7th and June 9th orders, and any future orders, that might be too open-ended for the court. We'll see. Calling the California National Guard into service under the stated authority of the president's use of 10 U.S. Code Section 12406 are unauthorized by and contrary to the laws of the United States. I'm not sure. This might be too open. B, injunctive relief prohibiting the Dodd defendants from federalizing and deploying the California National Guard and military without meeting the requirements of 10 U.S.C. Section 12406, which include the issuance shall be through the governor and only for the reasons set forth in 12406 and not to conduct domestic law enforcement activities. Now that word for word is absolutely appropriate request here. They're saying you need to stop this because they need to follow the law and they didn't, and then you need to tell them they need to follow the law. Award this and they didn't, and then you need to tell them they need to follow the law. Award the state of California its costs and reasonable attorney's fees, and D, such additional relief as the court deems proper and the interest of justice may require, which is our boilerplate close here. And then we've got this signed by the Attorney General of California here, all of these people, and the acting senior assistant attorney general here. So these are the attorneys for the plaintiffs. Wow, I would say that's an incredibly well-written discussion. Can Hegseth be impeached over this? It's possible. It's possible. So impeachable offenses need to be like high crimes and misdemeanors, right? That's how you impeach somebody. So anytime we're dealing with a overreach of power, could be seen in that light, which could justify articles of impeachment. Yeah, super crazy. I agree. Yeah, Rob Bonta. This very, very well written. It's nice and refreshing after some of the filings. Oh my gosh, everybody. I think we're up to 270 cases now filed against the administration since January 20th. I think we're at 270. But minus a couple that have finished. But yeah, we've got, oh my gosh, the litigation is just on and on and on. But I thought this was very well written, structured very well, and the different elements are all there that's needed, for sure, before it's too late. Yeah, that's really the question, too. I wasn't sure if this would be pushed through an emergency docket up to the U.S. Supreme Court or not. But it could very well be. I think I started tonight, before I really read into the details, I was like, man, no, it may not go down the fast track. But after reading it, it's possible. I would say it's absolutely possible that it could. I appreciate you. Oh, of course, Kat. Happy to do it. New sticky note for the closet docket. I know. Oh, my closet docket's getting so full. Do you know if there's a suit regarding RFK halting all vax? Not yet. Not that I've seen filed within the last few hours. But again, I think we'll absolutely see that. I think that will be one of the next cases. People are filing about, several cases a week for sure, but sometimes more cases, depending on exactly what's been said in the public. So a lot of times the actual evidence and violations of law are coming from the interviews and public press moments that the administration's having. So a lot of times after the Sunday shows, we'll get an influx of new cases because they've got more to add to the wrongdoings, because they will quote them from the Sunday shows. So we kind of waited out to see when the cases are coming through. But yeah, there's a lot. The calls with POTUS or the texts with his administration. I don't think they want to get that far into the weeds of it at the moment. I would say they're gonna wanna wait. This is a very I mean, this is probably the most important constitutional law question in play right now. And you might think, well, that's crazy. What about habeas corpus? This one right here, whether or not the president can override the governor when it comes to law enforcement and military, that's huge. I mean, this is enormous. The democracy question everyone's asking about, this is it here. All right. Yes, it will be. It's already a record. Yeah. Look, sir. We're already in record-breaking territory here. I think the first 100 days I had put all the cases together for the last like 4 presidents. And if you add them all together, it equaled like the first 100 days here. Oh, yes, of course, Lulu. Yes. Oh my gosh, the moderators work so hard. It's a horrible power grab. It didn't help anything. Well, there's a couple things about this. I get it. Like, I think California is the hardest state to beat. If they really wanted to beat this, if they really wanted to be like, okay, we're in charge, of state law and get it actually set out so that it could be used in the future, it's like they picked the biggest one of them all, and the one with enough resources to really fight, to go the full fight, is the other thing. Like you're not going to be able to come in here and say to, who do I want to pick on? Let me pick somebody that, who am I going to pick on? Indiana. You're not going to be like, hey, Indiana, we're going to come in and take your stuff. And Indiana's like, okay, we're going to fight it. And then they're like, oh my gosh, we've got nothing left. We can't fight you anymore. California, that's the one. That's where it is there. He has to respond in 24 hours. I don't think it's 24 hours. What happens after the complaint comes in is a lot of other things, because they're asking for a preliminary injunction, which is what everyone's been asking for, or they'll ask for a temporary restraining order, which again, these should only last for a couple of weeks until litigation really gets rolling. So they'll ask for a temporary restraining order, a preliminary injunction to get everything halted. And then whatever that decision is on that, then we'll go to the next level. And that will probably get appealed. So we'll have an appeal probably immediately. If there is an injunction or a restraining order, then the feds will appeal that, because that's what they do for all of them. Every single one of them, they have appealed. And then that Court of Appeals will make the determination about that preliminary injunction or restraining order. And then after that's decided, it'll go back down to the court again. And then that's when we can start going through and actually filing other stuff. But the response, to whether or not injunction's okay, that could be filed anytime. Will SCOTUS extend the time to handle the cases? So sad, so bad. I don't think they will. I think they'll come in, they'll step in. I think they're going to have a busy summer. I don't think they're going to be able to just like lollygag around this summer and go to like, oh man, where did Gorsuch go last year? Was it like Prague? It was some like, I'm going to be teaching in Prague for 6 weeks. Like, I don't know that that's going to be going on here. I think the court is going to be back on the bench quite a bit this summer, for sure. I don't think they're going to want to wait, because they know that it's important. The other thing too about the Supreme Court is like, they're like, we're special. So they're the ones that want to control what the end result is. And that means they need to get back to the bench. Tax dollars paying for the DOJ lawyers. Yeah. So, all of these cases are being fought by the Department of Justice. I mean, what's left of it? What's left of the Department of Justice? Can always jet someplace. True. That's true. All right, hold on here. Let me see. I can put this out here. Right, so here's our Supreme Court again here, and I have no doubt. I mean, they're dumping cases, which they're supposed to be doing. Right now, we're getting almost constant cases coming down, because there's quite a few left before they break for the summer. But once they break for the summer, oh yeah, they're going to be back. They're absolutely going to be back. I don't think they'll slow it down for anything. restraining order is put out, the department has to stop. Correct. Or a preliminary injunction. It should be, the order should be a temporary restraining order first, because that's your immediate, like within 48 hours. 48 hours, the court decides like, wow, let's get a temporary restraining order in place. And then the filings can start coming in and the responses. And then it can go into, this has to be requested. Also, the preliminary injunction needs to have a full request, and then they'll go through the briefing of that as well. So sometimes they're kind of merging into each other, but typically you're going to see a restraining order out first if it's like an immediate moment issue, and then preliminary injunction. Oh, thank you so much. Thank you so much. Yes, these are my happy rainbow nails. They're going to work through the summer. Yeah, exactly. Does the TRO send the National Guard home? Good question, and I'm not sure. I'm not sure exactly how they're going to phrase the temporary restraining order, because what they're asking the court to do, essentially, is to stop the federal government from using the California National Guard. So technically, but the federal government can use the National Guard, but they're asking for them to stop using the National Guard. So then the question is, what's going to happen to those 4,000 people while everything is paused for, a couple of weeks so it can go through the court system? Like, where are they going to stay? What's going to happen to them? Now we've got like real people, hardworking people here that are getting yanked back and forth between what's going to happen with the court. Because it's one thing for everyone to go in and fight and argue about stuff, but it's another thing when you're dealing with this many people. And that's been a huge issue with this particular administration. Law school in California, did they make a First Amendment argument? Might have missed it. No, I didn't see a First Amendment argument. I saw ultra virus argument, Administrative Procedure Act argument. What was the middle one? The second one was 10th Amendment. Yep. So state power, state rights. So those were the three pieces. So no First Amendment on this particular one. So let me just write that down. We had ultra virus. So exceeding your power. And then we've got the 10th Amendment. So this is, state rights, I guess we'll call it that. And then the third one was the Administrative Procedure Act piece. So those are the three claims. Yeah, 2,000. Thanks, Navy Vet. Appreciate that. I thought it was 4,000 plus some Marines. Weren't we at 2,000 plus another 2,000 and then plus the Marines? Ultra V race. Oh, thank you. I appreciate that. I'm going to always mess it up. I'm going to come in and I'm going to say this like the wrong way, but like 5 wrong ways. No jab available for that. Oh my gosh. Oh, thanks, Kaya. Appreciate it. Only 300 showed up. Okay, well, yeah, that's going to be a problem. That's absolutely going to be a problem. 300 National Guard. He said 2,000 to 3,000. That's quite a range we're getting here, everybody. That's quite a range here. 2,000 and then Marines. All right. I don't know. I thought the second 2,000's not on site yet. Oh, okay. All right, Navy Vet. Oh my gosh, thank you so much. Where were they for Well, who knows? J6 is a different animal, everybody, because the National Guard for J6. So, the governor here in California is like, dude, we don't need your help. And you need to ask us first. You need to ask permission, which is a problem, I think, for this administration. But then in DC, the person asking for the National Guard is the president, or like the, commanding officer of the National Guard. That's essentially the governor for DC. So the president's in charge of the DC National Guard. So that's why things are a little bit different with J6, because it was actually his job to make sure that there was enough safety in place so that all of the laws could be followed here. So right when Newsom's in here saying, we have enough law enforcement, all laws are being followed, we've got plenty of procedures in place, we're doing everything right. All of those things, that's what the president was supposed to have been doing in DC. Like, that's his job, because DC doesn't have a governor. It's the president's job. You're right, premature mobilization. Right, exactly. Yeah, you can't just federalize without requesting it or, consent. Consent's important. Uh, J6ers have lodging. That's a good point, Lavender. That's a good point. Can the Byrd rule stop all non-budget related power grabs from remaining in the recon bill? That's how it's supposed to work. Yes. Yes. And the Legislative Service Bureau needs to go through, and they're like nonpartisan. I know there's not much left, but they're nonpartisan. That's like just their job to go through and make sure that nothing's included in there that would conflict with the statutes and the law for what needs to be in it. New York City started protesting. I would say that's number two. So California and New York, I feel like New York's gotten so many good kicks in here. Oh my gosh, the kicks just keep on coming from New York. They're not even playing around. But they also have the authority potential to go forward just like California. I wasn't sure which one would be the first one to the line, and it's California. In North Carolina, really? Portland? Okay. All the amendments added last minute have nothing to do with the budget. Yeah, they try to do that, and then you gotta, kind of clean it up, which really is the mostly of what we're doing with a lot of different bills and things that go through. It's just a matter of like getting rid of all of the stuff that's they're like, oh, this is important. Let's put it in and make a big show out of it. And then the lawyers are like, yeah, that's not right. We gotta take that out. Who pays them? Right. So if they're federalized, then the federal government pays them. So that's why I think we've got some accommodations issues going on because somebody's too cheap to pay for what they requested. So you can kind of think about it like in that first administration when he invited, I can't remember who he invited in, but there was like fast food all over the place because they didn't have a chef at the time. So he like orders all of this fast food for like these athletes and they're like, oh look, it's a Whopper, yay. So yeah, I mean we're kind of in that area where it's like, well, we just don't want to spend the money. It's like, are you kidding me? This is a National Guard. I mean, they were pulling that kind of stuff with the Secret Service because they're like, well, we're going to be here, you're gonna have to pay if you want to be here, but to do it to a National Guard, like, that's just awful. With New York's votes, could that move to the rest of the country? So, that's a good question. Yeah, tacky and disrespectful. So let's just, a lot of people have been asking me about that New York uh, voting machine situation. And I see why it's hitting the news. And I definitely want to spend some time on it. This is it right here. I don't have time tonight. We can I'll give you a little overview here. But, I don't know, everybody. I don't know. I think it's great to go forward and make sure things are done the way they're supposed to be done. But in my opinion, it's just way too soon to make a determination of how important or effective or, how important this is going to be. It's too soon to tell, in my opinion. Yeah, too soon to tell. Yep. In my opinion, we just don't have the public. We just don't have access to it. This is another case that's going up on the closet docket, though. I will be adding it in my closet docket for anyone that doesn't know, where I'm tracking all of the lawsuits against the administration. So this one's going to have its own little section so that I can start following the court filings and such. But if you look, this was filed in December of 2024. And I just have to say, again, we had and do have, well, at least we had so many checks and hurdles and locks in place to make sure that everything was done properly, like more than ever before. And so for the people that were running the security, the locks in that situation, no one has come out and said there were some issues. So maybe they missed something, maybe they didn't. We just don't have enough information yet. And in my opinion, I'm not sure that we will, but we'll have to watch for it. I wonder how much my tax is paying for. Right. Well, I mean, they're paying the entire budget. I think it's a couple hundred, or is it a couple? What did I say? I forget now, everybody. I went through the DOJ budget. It was like, what, 2 million? It's got to be more than that. I can't remember now. The numbers get so big, I don't remember. Their entire budget, basically, the whole show that's being run with the DOJ is all taxpayer money given to them by Congress. So like all of it. I mean, and they're having to defend lawsuits where, they're just picking people up and putting them in vans and like sending them to random places. Right, right. The math ain't mathin'. I agree. I agree. At this moment though, this is one of those situations where it's like, let's keep an eye on it. Let's see what's going on. But I truly, truly think that had something major gone down, I believe it would have been brought to light. But what they're talking about here is what AOC was talking about the very next day after the election. And so she had already noticed some of the same things. So I think that that's really important too, because she's done a lot of research and has gone in and spoken with people and came back after she spoke with people and was saying this is why they voted the way they voted. So I'm not saying that it couldn't be incredibly important. I'm not saying that, but I'm saying right now we don't have enough. We just don't have enough. Yeah, the tabulations, right. We just don't have enough yet at this point. Yep. Right. They're overspending by a lot. Oh my gosh, DHS, everybody, like what? This whole thing it's crazy. We're in crazy town. There's a lot. Protests in Austin, okay. Public Law 102 they use for Iraqi and see if it applies here. Okay, all right, let me just write that in here. Public Law 102. Can you just appraise what the suit's about? The things they're alleging. So I've not spent a lot of time going through this. I want to actually do a full live on this, which I may do tomorrow. But basically they're saying that the numbers, the crunched numbers don't seem to match. And so there's this question about whether or not everything was done properly. So they're asking for a recount. They're not saying throw everything out. So just to be clear, unlike what someone else did when he said, well, we think that, things aren't going to work, so you got to throw out the entire election. No. They're asking for a recount here, and they're saying we've got justification for that recount. So, and then it would go forward from there at this point. So how many counties in New York have zero look? Well, that's a good question. I mean, I think it's important to investigate. I think this is good, but I also don't think this is going to be the remedy. I don't see this being a moment where, Kamala's like, all right, give me the keys, and like kicks him out. You know what I'm saying? I don't think that's necessarily where it's going to be, but I still think it's important to follow it up. Absolutely. Why didn't they recount from the start? We got to have a reason. You have to have justification. And there's only certain things that make it so that a recount's allowable. So for some reason, they just didn't meet all the factors, in my humble opinion. I think it occurred before the vote. Could very well be. It's possible. Election laws this time, the administration could bring those. They did change the election laws, but they didn't change it like that. The primary pieces that were changed were so that the people understood better that the vice president can't choose the president, and that you can't toss out electors. The whole fraudulent elector piece of all of this, they cleaned that up as well. So there was a lot of things cleaned up and safeties put into place. Like one of the biggest safeties now that was put into place was the governors needed to make sure all of the certificates were correct. They had to have some assurance on there by the governor of each state that their electors' forms were appropriate, and then they could only accept certain ones. So those kinds of rules were firmed up after the situation. Faux electors for hire. I know, right? Some article said it occurred before the vote. It could be an issue. It could absolutely. I mean, we got to look into it, right? We got to look into it. But also, we can't discount the entire network or system put into place to make sure that everything was done properly. And that entire system, which is huge and really was tight this year or last year, because they were so worried that a sore loser was going to come back and say, well, you guys screwed it up. And so every single inch of everything was very carefully and meticulously watched. That is where it's like, well, I'm not sure. Like, let's check it out, but, I'm not going to pin my hopes on it, because I feel like we would have heard something before this. Yeah, I think it's great. Talk about it. Absolutely. Talk about it. Talk about it. I woke up. Oh, Patricia. I'm sorry. This isn't the voice you want to hear to wake up to. Oh, sorry about that. Elon comes in. Possible. It's possible. There's an article in The Economist. Okay. Yeah. I've not done a lot of research here, but again, I do need to get it annotated and pulled out so I can start tracking it on the closet docket, because a lot of people are really interested in it. I think it's important to talk about it and follow it. And I'm not trying to poo-poo it. All right. I'm just saying, I'm hesitant. I'm hesitant to be like, oh yeah, let's do this and rally around it. I'm like, I'm going to wait and see. I'm going to have an open mind here. Yes, there were a lot. In fact, there were multiple states where cases were being filed during the voting, claiming the voting was getting screwed up. I mean, they were like cases like popping up left and right throughout the entire day. There were some places that sued because like the voting machines were like a fuse went out or something, and so they like were saying, wow, we don't know what we can do now. I mean, the judges were busy because there were so many lawsuits being filed on the actual day during the election. Right. Oh yeah, for sure. There's a lot. I gotcha. Can use the light. I see you with your red car. I got you. Okay. Right, Brandy. Yep, I agree. Right, exactly. I mean, at first glance, this is my first impression, right? My first impression is I'm hesitant, but it's only my first impression. So I would definitely be open to changing my mind. Sure. This time is, I tell you what, Blue, I've been thinking about it. A lot of people are saying you got to write a book, and I've been taking some notes, and I'm like, this is a little crazy. This is a little bit bonkers here. Oh my gosh. So yeah, so that's that. Oh my gosh. So yeah, so that's that. Yeah, we'll see. I'm open-minded here. I'm not saying it's not. I'm just saying, I'm open-minded. What's the next step for this one or for nuisance case? For the lawsuit against the National Guard situation? Write a book, I'll buy it. I pre-order. Oh my gosh. Really? Bestseller? Oh my gosh. I don't know. I'll have to put in there like, and I was so thankful for all of these amazing people that came onto my lives and asked me questions and reminded me to hydrate. Oh my gosh. So yeah, we've been talking about a couple of cases. So the one that I went through tonight was Newsom versus, these people here regarding the National Guard. This was just filed. And then I just was touching on the case that's going on in New York regarding the votes. The recount thing. Yeah, I'm not sure at this point. I have not pulled the docket, so I'm not sure. I've only pulled a complaint. I've got to kind of put the file together here. You did an audiobook. Oh, that's so sweet. That's so sweet. I'd have to do it in pieces. I'd have to be like, okay. We have to do it in like 90-minute segments. Very interested in the New York case. Yes. So again, just to remind everybody, I just have pulled the case and I've looked through it. I will be getting the docket put together and going through what's happening in this case. And we will put this up on the closet docket. So this will be a case that I will be starting to track the filings and where this is at in the process. All right, so I need a little bit of time to get it onto the docket. Again, we still have cases like left, right, and center being filed against the administration. We've got orders coming down. Court of Appeals is got 25 cases going in it now. So it's going in a Post-it note, you bet. Have they nominated a chairman for the FEC yet? No, not that I know of. Thank you so much. Yes, Willie B. Thanks for coming by. I appreciate it. Thank you for helping us understand. Absolutely, absolutely. I'm happy to help everybody. I know I'm a little bit, different. So I've got my I've got some fun things to just talk about. Some people are like, just get to the point. But I can't. I just have so much fun hanging out with all of you. So, but with that, my friends, I will go ahead and sign off for tonight. Yes, I need to go hydrate. I hit the 90 minutes and then I'm just like, that's the wall for me. So I'm so thankful you all came by tonight. I really appreciate it and all the questions. And hopefully this has given you a better look into what's going on over there in California. And also a reminder here that this guide is available online from the Brennan Center for Justice, which is part of the NY Law School. So they do great work and have kind of broken down presidential powers. They've been watching this for a while, so they are definitely keeping track of that. All right, everyone. So farewell for tonight. Thank you for coming by. Mini law school. Well, maybe more fun though, right? I will be back again very soon. I do have my Tube Tuesdays or Tuesdays on the tube tomorrow. So I'll be over on the tube if you're looking for me in the evening. So take care and I'll see you around.